No one wants to live in a house divided, which is why Jarrod Oxendine and his team are here to help when you need it most. This is A House Divided with attorney Jarrod Oxendine and Scott Rhino on Atlanta's only conservative news and talk station, Xtra 106.3.
Welcome back to House Divided with Jarrod Oxendine of the Oxendine Law Firm. This is episode 4. Oxendine Law is a divorce and family law litigation practice focused on providing personal attention to each client's unique needs. The experienced attorneys at Oxendine Law bring you clarity to your legal situation through their knowledge and resources combined with their consummate professionalism. You can reach the attorneys at Oxendine Law at 770-497-8688 or visit them on oxlawfirm.com. Jarrod Oxendine is the host of this show. This is his show. It is called House Divided. Jarrod, how you doing today?
Rhino, doing awesome. Excited to be back and super excited to bring on a special guest for everybody's benefit today.
Yeah, I'm excited about this as well because I've had a lot of questions about this. Obviously, I'm down at CPAC 2022 down in Orlando, Florida. So, we're doing it this weekend. We're live down there this weekend. I'm trying to connect back with you on this Saturday. It's been a crazy week down here, but I do want to introduce and joining us today with Jarrod Oxendine is Andy Flink. Andy is a mediation expert with Flink Family Law Mediation Arbitration. Andy has mediated over 1,000 family law cases. Yeah, a lot of them. I just looked at that number. I was like, that's 1,000 of them. He's also authored dozens of articles which have been featured in the State Bar of Georgia Family Law Review. Andy has also presented at several events focused on family law, presentations at the Family Law Institute, Lawyers for Equal Justice, Family Law Section of the Atlanta Bar Association, the Atlanta Chapter of the American Academy of Matrimonial Lawyers. That name is way too long, as well as the Cobb County Family Law Section. Welcome, Andy. Let me start with the basics here, Andy. I want to ask you, what is mediation? I mean, I know somewhat, but when it comes to law and divorce, why is it so important to have a professional mediator like yourself?
Well, thank you for the introduction. It's nice to be here today. Thank you, Jarrod. To get started, I would say that mediation is important because there are very few ways to resolve cases. Divorces can be somewhat contentious, and each side has a position in being able to step in as a mediator or neutral, try to help bring the parties to a resolution in a way that is not adversarial, and allowing the people to have a little bit of control over the outcome is very, very important. As a matter of fact, it's really, I think, one of the best, if not the best way to try to resolve divorce cases as opposed to going through litigation in court.
Christine Palmer is with us, too. And I'm sorry, Christine, I didn't even introduce you. Christine Palmer is the partner in Oxendine Law Firm. Hello, Christine. It's great to have you back. When you go into a case and you have a client that comes in and says, hey, we've been fighting back and forth, but I still want to move along with this relationship, then you find that, hey, we need a mediator. When you call someone like Andy Flink, what are you looking for them to do and to get accomplished?
That's the great thing about having Andy or any good mediator is they can accomplish pretty much any of our goals. I come to Andy. He has no idea what the case is, right? He shows up that morning, and I give him kind of an overview right then. So he is a true neutral. He's starting from scratch. He has no idea. So I tell him what's going on in the case, but I also tell him our goals. There are a lot of different potential outcomes for these type of cases. I can have Andy. I can say, look, the hardest part of this case is going to be custody. Let's just focus on that today. Let's not even worry about the money, or vice versa. Hey, we got custody worked out. Let's just focus on the money. Or I can say, hey, man, got a good one for you today. We're doing a little bit of everything. So mediation is not only beneficial to get the whole case resolved, but I've never been to a mediation that wasn't in some way beneficial in every single case. At a very minimum, you found out what the other side's looking for and what their currency is, so I know how to prep for trial. So if it was up to me, 100% of cases would be actually required to mediate prior to going to trial.
And Scott, one of the most beautiful things about mediation, and Andy will tell you this, is that, if you go to trial, you're just kind of throwing it up to the judge, right? It's up to the man or the woman in the black dress. You throw up your facts, and you're stuck with the outcome. The beautiful thing with mediation is you actually have control over what the outcome is. You actually can participate in what your final agreement and order are going to look like. And if you don't reach an agreement that you're happy with, you just simply walk away from mediation. But if you have something on the table that works for both parties, you then can sign off on it. It's binding, and you don't have to go to trial. And one of the other beautiful things about mediation, done several of these with Andy, is we sometimes can do like a pre-litigation mediation. So let's say you have a case where it's not technically uncontested because the parties still have a few things that they don't agree on, but they agree on 90% of it. But we maybe have, a few issues that we can't resolve. We can call up Andy and say, hey, Andy, we haven't filed this case yet. We want to actually mediate before the case is filed, see if we can resolve our remaining issues. We go to mediation, high chance at that point that we're going to resolve those issues. Now we have an uncontested divorce, and we simply go ahead and file everything at the same time, including the settlement documents, and finalize the case without having any contentious litigation.
What is the most common situation or the common issue that you say, hey, there's no choice, we have to get a mediator involved in this?
Well, it could be anything. It could be because we can't agree on the division of assets. It could be because we can't agree on custody or what the parenting time schedule should be or what child support should be. The only time you really should go to mediation is if both parties are willing. I mean, if one party is just going to check the box and they're not there in good faith, you're probably not reaching an agreement. But if you have good communication going on with the opposing counsel, the parties are communicating well, or even if they're not, they both have a desire to avoid litigation and trial, then it's always a great idea to go to mediation. And I agree with Christine. I think every case probably should be ordered to mediation. Frankly, a lot of the judicial circuits throughout Metro Atlanta will not give you a final trial unless you mediate. So Andy stays very busy. He's in a good business because I would say Andy can probably tell you the percentage, but I think at least probably 75%, if not more, Andy, of all domestic cases that are contested probably end up at mediation, right?
Yeah, they do, and I think many of the counties order mediation. They won't even give you a hearing before you attend mediation. But along the lines of what you were saying earlier, Jarrod, I think what's really important about mediation as well is that it's set up to be a format where it's really everybody against the issues. It's not necessarily a me versus you type scenario. And one of my jobs is to get a gauge on what I think each side's position would be in the absence of an agreement. So sometimes, if I'm working with Jarrod or Christine on a case, they may have been telling their client a whole lot of things that their client isn't listening to or won't hear. But then when I say the same exact things, they start to kind of listen and say, okay, well, maybe I should really take this advice and run with it.
I have a great story from our last mediation. So Andy and I just did
a
mediation last week, and we're both advising my client at this time kind of what number we're looking for. And he's telling me, what do you think, Christine? And what do you think, Andy? So Andy says, all right, Christine, he says, I'm going to write my number down on a piece of paper. Tell me what your number is. I'm going to show you. And we were pretty much right on target. I mean, we're like dollars apart. But yeah, like he said, like the client, that was so confidence building with him because both the neutral and myself, without speaking to each other, we're all on Zoom, right? We're all on the camera. You can see there's no magic here. He wrote down the number and mine's right on target. So it was something that in an exercise that let him know we're right where we need to be in this negotiation because we're not too high, not too low, and everyone agrees.
When we get back, we're going to talk more about mediation. This is House Divided with Jarrod Oxendine of the Oxendine Law Firm. When we get back, we're going to talk to Andy Flink about more of mediation and arbitration. Andy Flink from Flink Family Law, Mediation, Arbitration. And if you want to get in touch with Jarrod Oxendine, you can call the phone number 770-497-8688 or online at oxlawfirm.com. When we get back, we're going to talk more with Christine Palmer, Jarrod Oxendine, and Andy Flink of Flink Family Law, Mediation, Arbitration right here on Xtra 106.3.
Hey guys, what are you doing to invest in your home? Artisan Custom Closets is not only the best investment you'll ever make for your closet, but just wait until we redo your garage or add that custom golf locker. Talk about jealous neighbors. Artisan Custom Closets designs and manufactures custom storage systems, which means we save you money by eliminating the middleman. And speaking of saving money, make sure to ask for the Xtra 106.3 deal to receive 10% off. Invest in your future and make the neighbors take notice. Artisan Custom Closets.com.
Atlanta, it's Mark from the Safe House. We have an exciting announcement. The fake votes have been counted, and we're awarding Joe Biden our Employee of the Year award for 2021. Thank you, Joe, for helping us sell more safes than Barack Obama. You have single-handedly, or should I say single-mindedly, is that even a word, tried to destroy our economy in the past year. So keep it up, Joe. Us real Americans will continue living our lives until you are no longer in office. So, folks, if you want a real president, a real safe, drop by Atlanta Safe House or go to atlantasafehouse.com.
Hey folks, Chase and Penley General Manager Mike Bell Chevrolet. There's never been a better time to upgrade your vehicle than right now. The problem is most dealers don't have anything to choose from. No selection at all. Well, guess what? That's not the case here at Mike Bell Chevrolet. We're loaded with inventory, and we got tons of new vehicles arriving daily. Cars, trucks, and SUVs, and a wide range of pre-owned models to choose from as well. Everything from a starter car all the way up to a late model certified pre-owned. Everything for every budget and every credit situation. Now let's talk trade value. If you purchased a new vehicle in the last few years, chances are your vehicle is worth more now than it was when you purchased it. And we will buy your vehicle whether you buy a vehicle from us or not, regardless of your payoff. And don't forget, most of our vehicles come with a lifetime warranty at no additional charge to you. Mike Bell Chevrolet is home with a lifetime warranty. Why would you buy anywhere else?
Mike Bell Chevrolet, located at 1200 North Park Street in Carrollton, Georgia, and online at MikeBellChevrolet.com. Some restrictions apply. See dealer for details.
I have one question for you. Is it time? Hi, I'm Jonathan Geller of D. Geller & Son Jewelers, and if you're waiting for the right time to ask the love of your life to marry you, this is the perfect time. For a limited time, D. Geller & Son is offering 0% financing for 60 months. That's 5 years with no interest on all of our stunning engagement rings. Why are we doing this? Because our team wants to help you take one of the most important steps in your life with confidence. At D. Geller, our team members are treated like our family, and we all help each other like family. And if that's how we treat each other, just imagine what we will do for you. That's why our customers have come back to us over and over again for over 80 years. D. Geller & Son has been where Atlanta gets engaged since 1939. So, is it time? Come by one of our showrooms in Acres Mill, Kennesaw, or Sandy Springs, or visit us online at dgeller.com.
When you need an ally in your corner, Jarrod Oxendine is there. This is A House Divided with Jarrod Oxendine and Scott Rhino on Xtra 106.3.
Welcome back to House Divided with Jarrod Oxendine of the Oxendine Law Firm. Again, Oxendine Law is your divorce and family law litigation practice that you need to get in touch with. I've made the mistake before, and I got a divorce, and I never called the right lawyer. I should have called Jarrod Oxendine or Christine Palmer over at Oxendine Law, and I messed up. It cost me, so don't let it cost you. You can get a free consultation at any time with Jarrod or Christine. The phone number there, 770-497-8688, or online at oxlawfirm.com. Also joining us today is Andy Flink of Flink Family Law Mediation Arbitration. We're talking about mediation and how important it is. Why is it so important, especially with a family, Andy, to come in and have a lawyer call someone like you and say, mediation is needed, and family is involved in this one?
Well, typically it's because, as I say to people, and I've been down that road myself, I say to clients, I'm sitting in my chair because I sat in your chair before. The person sitting in that chair for the first time has really no idea of the landscape that's out there, what needs to be done, what the legalities are, what's important, what's not important in terms of what the court might see. So I think that it's vital for an attorney to be able to explain and advise a client on what rights they may have, what a parenting plan is, what a child support worksheet is, what are important components about an agreement. And all of those things we can work out in a mediation format. So you don't want to walk into these things blind, and you need to be educated. Truth of the matter is that most people have not been through it before, and if you haven't been through it before, you don't know what the landscape looks like, and you've got to talk with somebody who's experienced, like these two experienced attorneys that I'm sitting with today in the studio.
Well, thanks, right, Andy. And Scott, I'll also say if you hire the right attorney, they'll get you in with the right mediator. Right? So a good attorney knows the good mediators, and Andy's one of them. And what I mean by a good mediator, I've had plenty of poor mediators where they literally show up and they just shuffle paper back and forth, right? They take an offer from one room to the other and back and forth. They're not reading the parties. They're not leaning on the parties. Keep in mind, as an attorney, by the time you get into mediation, you've probably lost a little bit of your objectivity, right? You're kind of welded to your client. You're an extension of your client. The good thing about the mediator, if you've got a good one, is that they actually will give you a third point of view, right? They'll let you know if one of the positions that you're taking is unreasonable, or they'll let you know if one of the positions that you're taking is reasonable. And so that's very helpful to get a case settled, because then the mediator is going to leave your room, go to the other room, and do the same thing. And that's what slowly brings the parties together. So if you get the right attorney, you'll get the right mediator.
And Christine, I want to ask you a question, and Jarrod just said, Andy is a good mediator. He's one of the good ones. So are there different mediators that you go to for different situations? And why would you go to a different mediator, Christine, when a client comes in, you say, hey, I got the perfect mediator for you?
Yeah, actually a great question. Andy is one of my, and I'm not just saying this because he's sitting here, Andy is one of my jack-of-all-trades kind of mediators. I can bring family issues to him. I can bring financial issues to him. There are mediators out there who really have a forte, who are really good at the finances. They're really good at money. They're really good at numbers. They may have CPA or financing backgrounds in addition to their law backgrounds. And there are mediators out there who really are kind of like hanging out with your aunt. I mean, they're just a true soft touch. They may not be as good at crunching the numbers and getting the percentages just right, but they're going to be a shoulder to cry on in a way. They're going to be a little more emotional when they're speaking with clients. And sometimes, if the money's not the problem, and then we're just talking about, oh my God, I can't go 3 whole days without my son, I'll die. I need a parenting plan. Some media that maybe is a little more on the emotional side, or a little more sympathetic, or a little more patient when it comes to those things, might be the right touch. So it definitely is important to make sure your mediator fits your client, for sure.
And Scott, one of the cool things about mediation, you can tell we're big nerds when we start talking about this, but, I got something called a marital balance sheet. And I won't lie, Andy actually is the first person that turned me on to the marital balance sheet. Andy is known as being very good when it comes to finances. So let's say you've got a complex divorce case that involves a lot of money. You have a lot of homes, you've got a lot of financial accounts, retirement accounts, bank accounts, maybe even have a business, and we've had to hire an expert to do a business valuation to see what the business is worth. We've got this cool thing. And my office always prepares one in advance of mediation. If you hire Andy and you don't have the marital balance sheet, he'll actually prepare one for you during the middle of the mediation. But what's cool about it is it's like a spreadsheet that has all of the assets listed. It has the value of all the assets listed. And at the end, on the right-hand side column, you have a column for husband and you have a column for wife. So what we'll do in mediation is we'll start moving these assets into husband's column, into wife's column. Wife gets the beach house, and husband gets the marital residence, and wife's getting the 401k, and husband's getting the IRA. And it'll give you a running tally what husband's total column is worth, what wife's total column is worth, and an overall picture of what all the assets are, so that everybody's on the same page. If you don't hire the right attorney, if you don't have a good mediator, you're not even going to know that a marital balance sheet exists, and that is so helpful towards resolving these complex cases, right, Andy? I mean, you use them all the time.
Yeah, and it's a great tool to have. And once I'm able to get all the numbers on the page, objective number one, obviously, is do we all agree on the total number? If we can all agree on the total number, then we can start taking that number and dividing it. And the beauty of a program like Excel, I mean, it sounds overly simple, but I create the balance sheet, and then I get the information from one room, and then I go in the other room and I show it to them, and I just do a cut and paste so I can compare how far apart we are between the rooms, and we just continue to narrow that gap as much as we can. And once people can see that visually, they start to understand, okay, now I get it. Now I see where we're apart. Now I see what we need to do. And it's a compromise, right? I mean, both sides have certain expectations as to where they want to end up. And I always say that I'm pushing people more and more away from where they want to be. And what do we say? The sign of a successful mediation is where both parties walk away unhappy.
That's exactly right.
Yeah.
There you go. And now, Jarrod, I want to go back to something you said a little bit earlier, unreasonable versus reasonable requests. When they come to you and they ask these questions and they say, hey, this is what I want, this is what I don't want, whatever it may be, what are some of the really unreasonable things people ask for when they go to mediation?
Well, for example, if you've only been married for 2 years and you go to mediation and you're asking for alimony for 15 years, right? That's not reasonable.
Right.
No, that is not reasonable.
Or let's say that you go to mediation and you ask for 90% of the assets, and you think your spouse should only have 10%, and simply because they were not nice to you, right? I mean, there's certain things that are reasonable. There's certain things that are not reasonable. And it's helpful to have a third-party neutral there that can help you, frankly, with your client and lean on your client and reinforce what you've already told your client is reasonable versus unreasonable. And not just your client, more importantly, the other side. A lot of times we go to mediation. Of course, it's always the other side that's the problem, right? But we go to mediation and we think the other side is unreasonable, right? We can't believe they're asking for this. Oh, my gosh, what are they thinking? This mediation's done. We're about to walk away right now. I'm sure Andy hears that all the time. Best and final offer or we're walking away, right? Half the time that's a bluff. But what Andy will do, right, is he's in the other room working that side too, right? If they're being unreasonable, Andy's letting them know that they're being unreasonable, and hopefully we all come together because the goal of mediation is to settle the case. And why do we want to settle the case? I love trying cases. That's the fun part of my job. But people are usually happier when they have control of the outcome. If you go to trial, especially if you have kids, you're in there slinging the mud, man, right? I mean, you're airing the dirty laundry. And then what happens when y'all walk away from trial, regardless of what the outcome is, y'all probably don't like each other as much as you would have if you had reached an agreement. And you've got these kids that you got to raise for all these years. So why not kind of keep all the dirty laundry in the closet, right, and resolve your dispute amicably, because you're going to be happier. Your relationship with your ex is going to be better. And more importantly, y'all both can work better with each other towards what's best for the children.
Yeah, and when you said that the wife gets the beach house and the guy gets the regular house, I don't like that they always get the beach house. Why can't I get the beach house every once in a while? Christine, I want to ask you about this. So do you have a situation where someone said, hey, and they were being completely unreasonable on the other side, and you said this is just not going to work, and you've actually had to get up and leave the table?
I mean, of course, there are times where a mediation ends in a complete and total impasse, but that's very rare. I am there to salvage any mediation. If I've attended, I want to have something to show for it. So even in those circumstances, it's frequent that at minimum I can say, all right, can we at least stipulate to these three things, right? Can we at least get a partial agreement today? Or, all right, nobody's in love with this. Can we make it a temporary? And we'll see where things go from here. And we've got from now until the final trial to either tweak it with a new settlement, or then by then, we'll go and let a judge make a determination. But yeah, I mean, there's of course times where we're so far apart. I've had one very recently where, I mean, I don't even know. I don't think we're trying the same case. I walk in and I was like, I don't understand what we're doing. And the mediator, who was not Andy in that case, came to me and said, does this other attorney even do family law? And I said, no, she does not. So that's a big part of it too. And I think Andy can talk to us about management of client expectations from one attorney to another coming into mediation, and how that makes a difference when you're in the mediating room.
Yeah, fortunately for me, we in this business have fact patterns and have a pretty good idea of what we think the range of settlement is given the facts of the case. So one of my jobs is to keep in mind what the range of settlement is. So visually speaking, if you have an 8.5 by 11 sheet of paper, the settlement's got to fall somewhere in that piece of paper. I mean, ideally it would be right in the middle, right in the bullseye,
sure.
If it's fair and equitable to both parties. But by the same token, certain clients are willing to do certain things or give a little bit more, or other sides want a little bit more, and that bullseye is not in the center of the of the page, but it's got to be somewhere on the page. So to Christine's point a moment ago, if I sense that there's going to be an offer or a proposal that is, my analogy is that it's not even in the stadium right now. We're still tailgating in the parking lot. So it's and I'll be honest with you. First offers a lot of times are in the parking lot as tailgating offers. So as I say, and it takes 1 or 2 rounds to get people into that range of settlement where we're on the piece of paper.
And Scott, something else I think is important for the listeners to know is something else that happens all the time at mediation. Let's say we make a lot of progress and we've agreed on most everything, but we just have a few issues that we just have an impasse on. A good lawyer and a good mediator like Andy will be able to reach a partial agreement at mediation. So in other words, don't think that when you go to mediation, if you can't resolve everything, that you have to walk away with nothing. If you've got a good attorney and a good mediator, you actually can go ahead and reach an agreement on everything that you're in agreement upon and just reserve those remaining issues for trial. I just did that this past week. We had a mediation about a month ago. We resolved everything except one issue. Now, it's unfortunate that you resolve everything except one issue, but it was an important issue. So we reserved that single issue, and I had a trial on it this week. So, there's a lot of options here. You just have to have the right experts on your side so that you know how to navigate it.
This is House Divided with Jarrod Oxendine of the Oxendine Law Firm. Again, a family law litigation practice, divorce and family law. You can call them 770-497-8688. Christine Palmer is here with Jarrod Oxendine, along with Andy Flink of Flink Family Law Mediation and Arbitration. And Andy, I wanted to ask you this. They're talking about partial agreements and mediations. How long can one of these mediations last, and how often does it just happen in one setting where everybody just kind of agrees and everything is taken care of right then and there?
Wow, that's a tough one. I mean, they're all over the board. But I would say, generally speaking, if you are going to reach a full and final agreement on all issues, custody, equitable division, support, you're probably, generally speaking, looking at anywhere from about hours to, 8, maybe even 10 hours in one session. A lot of times, recently it seems like a lot of cases that I have, or some cases that I have, I should say, we do second sessions. So, for example, we'll come into the first session and there'll be some issues with discovery. There'll be some disagreements in terms of valuations, things like that we need to work out. And, we'll come back for a second session to iron it all out. But they really are all over the board. I used to, in my infancy days in doing mediation, would go, till 8, 9, 10, 11, midnight. But I honestly have found out over the years that nothing good happens in mediation after about 7 o'clock at night.
Very true.
That is
People
true.
get hangry.
Yeah, everybody gets angry. Everybody's been sitting around, and they're already angry being in that situation. Now, Andy, I want to ask you this, too, because you deal primarily or only really with lawyers, divorce lawyers, that they come straight to you. What is the one thing that you ask lawyers? Like, hey, you need to be prepared. This is what I need from you. What do the lawyers need to do when they contact you?
Well, the first contact that I have with lawyers is there's a session that's booked. And most of the time, I don't really know what the case issues are going to be until I appear that day. But, I have such a great trust for the people that I work with that I know that when I start in the morning and I introduce myself to their clients, an idea of what the case is all about, then at about the first 15, 20 minutes, I've got a pretty good idea of what we've got to deal with that day.
And so do you talk to both clients separately as well and then try to figure out from both clients what they're really, like the real true story, try to find, both sides of the story by talking to them individually? And then, what is your specialty? Obviously, we talked about the financial and the marital balance sheet, but what besides finances is something that you have to look into and say, hey, this is one of my specialties as well?
Well, it's a great question. So first of all, understand the setup, okay? Pre-COVID, I did all my mediations in person, at a lawyer's office, conference rooms, day offices, in person, in separate rooms. So I would say I haven't done a mediation where everybody's been in the same room in probably 6 years.
Wow.
So the setup is, and now it's all Zoom. I would say most, if not all of what I do now is Zoom. So I will gather, I'll get client and attorney in the Zoom room. I'll move them into a breakout room. We'll do the same thing with the other side, and then I'll go back and forth between the Zoom rooms. Rarely do I talk to a client without the attorney present, unless because on Zoom, somebody will mute their video and I won't see the attorney, so I'll start talking for a few minutes to the client. The attorneys are typically fine with that.
Yeah.
And Scott, what I want to make clear to your listeners. We're talking about Andy asking questions and going room to room. This is a very informal process, right? So I want everybody to understand this. Andy's not a judge, right? So Andy is a mediator. His role is to promote and encourage settlement. He doesn't then make a decision at the end of mediation as to what the final outcome is. The only way we settle is if the parties mutually reach an agreement. So it's a very informal setting. It's not like court where you've got to get dressed up in your Sunday best and you're on a stand and you're getting interrogated by attorneys and asked questions and on the spot. No, this is very informal. You show up with your jeans and your sweatshirt if it makes you happy, right? and you lay back, you let your lawyers do most of the talking. Of course, there's naturally going to be questions that your lawyer is going to ask you, or that Andy or the mediator is going to ask, but the opposing counsel is not in the room. They're not asking you questions. We're not doing formal rules of evidence where people are testifying and being cross-examined. It's a very laid-back, easy process.
Jarrod, I want to ask you this. Arbitration. What do you need to do with arbitration, and why Andy Flink, and why would you call Andy and say, hey, we have an arbitration case we need, and maybe even tell people what arbitration is?
Well, so the difference, you know what, let me let Andy describe the difference between arbitration and mediation, and then me as the attorney, I'll kind of tell you why I might think a case would be good for arbitration versus mediation or trial.
So, to answer that question, in mediation, I'm the neutral. I'm trying to work with both parties individually to get them to make certain concessions to outcomes. So basically in mediation, the parties and attorneys have all the control over the outcome. I'm just trying to help them get there. Arbitration basically is an informal court. It's basically where I am in place as the judge, if you will, and I'm brought all the components, and each side presents their case, and then I'm charged to essentially rule on the case and draft an order saying, okay, based on what I've been told and based on the testimony, this is what I believe to be the outcome. But I do want to mention one other piece, and this is, I think, really important to the process for your listeners to know, is that even when I'm put in a position to arbitrate, I will always start out in kind of more of a mediation headspace. So a lot of times what we'll do is we'll do what's called med-arb, where we'll mediate for 2 or 3 or 4 hours, and then if we don't reach agreement, we may go back to arbitration another day, or we may arbitrate right then and there, depending upon how the lawyers feel about the case, and obviously approving that with their clients. But basically arbitration in a nutshell is where the arbiter basically rules on the case and makes the decisions.
So, yes, Scott, so Andy stole one of the points out of my mouth, which is the hybrid. And I love the hybrid. And not every mediator and arbitrator will do the hybrid. But the hybrid's a beautiful thing, right? You start with mediation. You see how far you get. If you reach an agreement without having to go to the arbitration phase, you're done. You never get there. But if you have to then convert to arbitration at the end or come back a different day for arbitration, you don't have to start over from scratch, right? I mean, if you stop the mediation and then go to trial, you're going to a brand new person. You got to present all of your arguments and your facts and your witnesses and your evidence, as opposed to just going to the arbitrator that already mediated the case. They're already familiar with the facts, already familiar with the evidence. It's a much quicker and cheaper and easier process. The other reason I would choose arbitration instead of trial would be maybe I know something about the judge, right? So the good lawyers in town know their judges, right? And you know what a judge is likely to do with a particular fact pattern. And if you find yourself with a client that has a fact pattern and a judge that would not accept that fact pattern, then if you can get the other side to do an arbitration, you actually have a chance at getting a result that you would not get at trial, right? So in those circumstances, we might see if the other side would do arbitration, which is a binding decision. That's Andy or the arbitrator acting like a judge. You present your facts and your arguments to the arbitrator, and at the end they make a binding decision just like a judge. But it's almost like a way, frankly, to shop your judge, which you can't do in trial, right? When you file your case, you're stuck with whatever judge you get. But if both sides are willing to arbitrate, and you get with the right arbitrator, then you can get more creative and you can get a better outcome at arbitration than what you would get at trial. Christine, you got any other reasons why you might choose arbitration instead of mediation or trial?
One of my absolute favorites is that I get to set the date, time, and location for arbitration. I have recently filed a motion for a final trial in a metro Atlanta county, and I was set down for September of this year. I would much like to get these parties divorced prior to September. So opposing counsel and I are discussing doing an arbitration session so we can actually have a result final for these parties way prior to what the court could resolve it, because we've had a lot of backup due to COVID and other things. And that actually is one of the biggest benefits is I get to set the date, the time. If I have an out-of-state client, I can set it and it's not on a court's calendar. They know when to set their flight for and when to be in town. So that's one of the other bigger benefits of arbitration.
All right, this is House Divided with Jarrod Oxendine, and Christine Palmer is joining us, as well as Andy Flink of Flink Family Law Mediation and Arbitration. If you need to get in touch with Jarrod Oxendine, if you need an arbitrator, Jarrod and Christine know the people to go to. Get in touch with Oxendine Law Firm. The phone number is 770-497-8688, or you can visit them online at oxlawfirm.com. When we get back, we're going to talk a little bit about arbitration and other reasons why you might have to go to arbitration over a mediation. That's going to be important as well. So we're going to talk about that when we get back right here on House Divided with Jarrod Oxendine of Oxendine Law Firm on Xtra 106.3.
Your Atlanta Braves are World Series champions, and baseball is just around the corner.
The Atlanta Braves have won the 2021 World Series.
The 2022 season schedule is jam-packed with great matchups. Truist Park hosts the Cubs in April and the Red Sox in May, and the summer is filled with exciting home series against the Giants and Dodgers in June, the Angels in July, and the Astros in August. These are games you won't want to miss. Tickets are going fast, so don't wait. Get your tickets now at Braves.com/tickets. Atlanta Braves baseball for the A. Convenience is defined as the state of being able to proceed with something with little effort or difficulty. Well, at RBM of Atlanta, we embody this philosophy. Meet our Mercedes-Benz pickup and delivery service. It gives you back time and money. Does your Mercedes-Benz need service? If so, we'll pick up your vehicle that's requiring service from your home or office and bring it back to our dealership for the required service. With over 100 appointments available every weekday, over 50 appointments on Saturdays, and more than 200 courtesy vehicles in our fleet, we're here to serve. We'll work around your schedule. We're here to save you time, energy, and money. Find out today why we are a 2021 J.D. Power Dealer of Excellence, a 4-time winner, and Atlanta's only 6-time Mercedes-Benz Best of the Best winner. We're proud to be Atlanta's Mercedes-Benz connection since 1964. Pickup and delivery service restrictions do apply. Ask your service coordinator or service advisor for details.
It's time to say goodbye to that cold, drafty house of yours. No, I'm not saying you need to move. You need to make your current home more comfortable. Here's the problem. No matter how good your furnace is, it can't keep the warm air from leaking out of your house. That's why you need better insulation. USA Insulation. When USA injects their premium foam into your walls, it's like wrapping a coat around your entire home. And then when they insulate your attic, it's like putting a knit hat on. I've heard home inspectors say they can tell a home has been insulated by USA Insulation as soon as they walk in the door. They can feel the difference. You've made improvements to your home over the years, but don't forget comfort. It's hard to enjoy anything when your house is cold. USA Insulation fixes cold homes. Give them a call today. They can insulate your home for as low as $99 per month, which lets you help pay for the insulation out of your energy savings. Stop freezing and start saving. 1-800-USA-FOAM or usainsulation.net.
USA Insulation.
You've been listening to Ray Giudice for years. He's a smart guy. You know he knows DUI and criminal law. He's been in practice for over 30 years. But did you know Ray knows some of the best legal minds in the business? From labor contracts to real estate to divorce. Ray can help you through it all. He can put together the legal team you need. He's the guy you call when you've got legal questions. So call him at 404-964-4185. Ray Giudice, 404-964-4185.
America's talking to Fox News.
Ahead of a potential guidance update from the CDC, many cities and states are beginning to roll back mask and even vaccine mandates. Are you comfortable with this change?
I think it's about time. I think it's great because everybody's just sick of it. It seems like the numbers are way down, so it's time.
The problem is that there's no assurance that we're off this roller coaster.
I think that it just puts everybody at a little bit more ease.
I'm excited. I'm looking forward to just seeing people's faces in the grocery store.
I think it'd be great. Get rid of this. I'm all for it.
It's been a roller coaster for everybody. You know, trying to keep up with the restrictions and the mandates, that's been a challenge.
I do think you can relax mask mandates in stores, but mass gatherings, I would not relax mandates.
After 2 years, it's finally a step in the right direction. There should be no mandates. If you want to wear a mask, that's completely and totally up to you. That's your right. But to enforce something upon others is wrong.
America's talking to Fox News.
When you need an ally in your corner, Jarrod Oxendine is there. This is A House Divided with Jarrod Oxendine and Scott Rhino on Xtra 106.3.
Welcome back to House Divided. It is Saturday. Every Saturday you can catch House Divided with Jarrod Oxendine of the Oxendine Law Firm right here on Xtra 106.3. 10 a.m. till 11 a.m. You will will be able to get every answer you need when it comes to divorce and family law litigation with Jarrod Oxendine. Of course, Ox has been named, and I like the fact that I am. Is that all right? Can I call you Ox?
Yeah. You call me Ox since high school, and I love it. The Ox.
All right, good. The Ox, yes. Ox Law, I mean, that's the reason why. So if you need to get in touch with the Ox, again, 770-497-8688 or online at oxlawfirm.com. We're talking about arbitration and mediation with Andy Flink of Flink Family Law Mediation Arbitration. And this is a really important subject for a lot of people. You need to get in mediation, and you need to get in touch with Jarrod or Christine Palmer over at Oxendine Law. Get a consultation and say, hey, we need mediation, we need arbitration. And I want to ask, Jarrod, what's another reason why you would go to arbitration other than, like Christine brought up in the last segment, so you can set your own date, makes it easier, and you don't have to worry about picking a judge, and you know who you're talking to already with an arbitrator like Andy Flink. What's another reason that you would call Andy and say, hey, we're going to arbitration?
Well, you can save time and money. Preparing for trial can be very expensive. They say the rule of thumb is for every day of trial, you got to have 2 to 3 days of preparation. So, you got to get direct examination questions ready, cross-examination questions ready, opening statements, closing statements, get your witnesses prepped and ready to go, get all your evidence gathered together in an organized fashion so that you can present it to the judge. Arbitration doesn't require that much time and preparation. You still have to prepare, obviously. We're not walking into an arbitration unprepared, but I would say the time to prepare for an arbitration compared to a trial is probably a quarter of the amount of time. So you save time, you save money, and frankly, arbitration is becoming more popular. Back in the day, it was unheard of to do a divorce case or family law case as an arbitration. Now it happens a lot. Frankly, I think, there's a lot of lawyers out there that don't even think about that. The inexperienced lawyers don't even think about arbitration as an option for their family law and divorce cases. But it's becoming super popular. Frankly, I know Andy's got several staff members over there that do exactly what he does because he's been so busy, right, Andy?
Yeah, and I meant to do this shout-out way earlier, but I wanted to mention I have a couple of associate, they're attorneys that work with me as mediator arbitrators. Erica Arena Camarillo and Lawrence Smith are both family law attorneys in the Atlanta area that do an excellent job in mediation and arbitration. So that if I'm not available, you can always check their calendars. And I also need to give a special shout-out to my admin, Michelle Burden, who, if it wasn't for her, I probably wouldn't know what case I had what day and would be running around not knowing anything about any of the cases I have. So
I'm backing that one up. I think Michelle knows more about my calendar than I do some days. So, I appreciate her. Thanks, Michelle.
Basically what Andy's saying is he has a second wife, too. Like I have my office wife. Andy has his office wife as well.
All right. Well, you know what? I might need to get Michelle because I don't know how to manage myself in my schedule. So, good job, Michelle. Way to get a shout-out. That's one of the best shout-outs I've ever heard. Andy, I want to ask you about something that Jarrod had said before. He actually prefers a hybrid, a mediation and an arbitration. Do you usually suggest to the lawyers, like, hey, this is a arbitration case? Do you have to suggest that, or do they come to you? And would you rather do a mediation arbitration hybrid?
I'm a fan of the MedArb. They call MedArb hybrid because I want to give people an opportunity to try to resolve the cases as much on their own as possible. And if I need to step in and make some decisions on behalf of the clients and their attorneys, I'm happy to do it. I mean, if you remember before, I was saying that I'm always considering the range of settlement, right? So I know sort of where I think, generally speaking, a court might rule on a particular issue. I mean, there's always outliers and situations that may be, outside the norm. But, 99% of the time, like, for example, if I have a case that I mediate and don't get a chance to arbitrate, when I find out what the outcome is, whether the parties go to court or they go to arbitration, I'm pretty close to where I thought the case would end up. So to Jarrod's point, it is much, much more efficient. It's much less expensive. And the ability to get in and get a case resolved in a reasonable period of time is key. And also arbitrators, I think, will look at cases with more of what we call a scalpel as opposed to, judges have so many cases before yours and so many cases after yours that it's really hard to get the same audience. Some of the judges that I've worked with are spectacular. Many of the judges I've worked with are spectacular. So it's not a diss on that process by any means, but it's just hard. Like Christine was saying, I mean, she's got a hearing coming up in September, and that's probably on a trial calendar, so that could move to October or November.
What are other reasons that you would go to arbitration or that you love besides it being cheaper or dates? Are there other reasons that you say, hey, I think we should take this and make this a hybrid? We'll go through mediation and then hopefully get to arbitration, especially if you know the other lawyer, like, hey, we can get this over on this lawyer and get you what you want by going to a mediation arbitration like a hybrid.
Yeah, for sure. One of the things that I love about an arbitration session when I'm preparing, so if I know a case is going to arbitration, I am, for the end result, preparing it the same as if I'm going to trial, right? I am still presenting my case knowing that the person I'm presenting it to will be making the final decision in my case. The good news is if I'm going before a judge, I am bound to the rules of evidence. So I have to tell my client, all right, if you want the judge to consider school records, you got to take the certificate of authenticity. You have to go to the school. You have to get certified copies of the records. You have to bring it back. I have to either subpoena someone from the school to be present to testify to their authenticity, or we have to work in advance to get the business records certified, things like that, where in arbitration, they're the same documents. I just don't have to go through all the legal loopholes to let Andy consider them. I can say, hey, we got these directly from the school, and he takes me at my word because it's an attorney presenting it. But I get to a few of these like formal rules of evidence. Also things like hearsay, right? So, well, the teacher told me, objection, hearsay. Things like that, they can be considered in these mediation arbitration sessions because we're talking about them openly in hopes of getting a settlement first. And then at the end, Andy has all the information without having to go through all the legal loopholes to make sure that he's considering it.
Scott, something else I want your listeners to know, and this is more on the mediation side than the arbitration side, but we can get really creative in mediation. So in other words, what I mean by that is we can do things at mediation that the judge can't do because the judge doesn't have the authority to do it. And one example on that is college expenses. I'm not sure if your listeners know, but the judge has no authority whatsoever to order either parent to contribute towards college expenses because at that point that child is no longer a child. They're an adult. Well, guess what? In mediation, we can get creative and we can come up with like a clause that allows for payment of college expenses. We like to call it the UGA exception. And I know Andy graduated from Georgia, so he's a Georgia fan. But what we do with that is we say, okay, both parties are going to pay 50% of college expenses, but the cost can't exceed what it would cost to attend the University of Georgia based on in-state tuition. And if the parties like that, they can agree to it at mediation. But if you're from the judge can't even order it. So you're kind of handcuffed. So you have the ability to get very creative in these mediation sessions.
And here's another great example, if I may. You can have someone who their child is graduating 9th grade this year, and they can come to an agreement that basically says that one of the parties may keep the house for the next 3 years, and they're going to sell it when their son graduates high school. A judge would not ordinarily do that. If the parties come to court and say, listen, I want the house. No, I want the house. No, I don't want him to have the house. No, I don't want her to have the house. The judge will say, I got a great solution for you. Sell the house.
That's exactly right, Andy. And, something else that's important. One of the things I love about mediation is it gives you a glimpse into what the other side's going to argue if you don't settle and you have to go to trial. So I can take depositions, I can get prepared for a trial, but in a mediation, we're getting offers back and forth. And so I now know exactly what the other side's going to argue. I know pretty much exactly what they're going to ask for at trial. So that way, even if we don't settle at mediation, it actually helps me to prepare for trial to attend a mediation prior to trial. So lots of benefits to mediation. It's just a beautiful thing.
This is House Divided with Jarrod Oxendine of the Oxendine Law Firm. You can get in touch with Jarrod at 770-497-8688 or visit them online at oxlawfirm.com. Also, Christine Palmer with Oxendine Law Firm is here with us. She's the manager, or the partner, the attorney partner, I guess is the proper term, correct, for Christine Palmer. And Andy Flink of Flink Family Law Mediation and Arbitration. And Andy, I wanted to ask you, when it comes to children being involved in these kind of separations and divorces, mediation, and if someone comes to mediation and arbitration with you, do you want to talk to the children and get them involved in this as well?
I've never spoken to a child in the thousands of cases I've ever done.
Wow. Okay.
I'm not even sure that that's something that I've had it suggested. I'm going to can I bring my child in to talk to you? I will never do that.
And Scott, that's probably because if we've made it to the mediation mark, we're at least at the point where we know we're all negotiating in good faith, and we don't have to do that. That's a pretty dire circumstance to involve the child directly. So if we have made it to the point where opposing counsel and I have agreed to go to mediation, we're probably past the point of needing direct testimony from a child.
Yeah, and there's someone called a guardian ad litem that might enter a case that essentially represents the children where one lawyer represents the father, one lawyer represents the mother, and then, if there's a dispute on custody, it's pretty common to have a guardian come into the case and assess the situation.
And that guardian will be at mediation with us.
That is correct, yes.
That's it for House Divided. We're already at the end of this episode. I can't believe it went by so fast. We'll speak to you guys next week. If you need to get in touch,